Ms. Rush, are you on the line?
But she might not be, Judge. We've been going back and forth with the GAL on this. I think everybody's agreed that this just goes over. It's a complicated case.
Okay.
GAL continues to work on it. If we set that over, I think we're all agreed to do that.
And is Julie Marcotte on the line? All right, Ms. Marcotte, if you're here and you're speaking, I can't hear you, so make sure you're unmuted. And the same thing with Ms. Deanna Rush, if you're on the line. So we're here for the final GAL report. It's no report.
Ms. Rush is calling me right now on the cell phone. So there might be connection issues.
Go ahead and call or answer. It's fine.
Okay, we're literally on the docket and on the record right now. Judge Evans is looking at me. No, it's okay. He just called Marcotte. Are we good setting that over? Perfect. All right. I already did. Thank you. She's in agreement, Judge. Sending that over.
Okay, that sounds great. And is Heather Call on the line? Heather Call? GAL? Okay. It'd be helpful to have her input as far as timeframes of when to set it over. Any indications that you've heard from her?
I think we're into September, Judge, and there's actually 2 on the docket today that I have where very similar timing with everything. I think she needed about an extra 3 weeks to a month. So maybe one of those early days in September would be good. I believe the September 4th date, is that the Tuesday?
It would be a third, be Tuesday.
Yeah, let's go a week after that. Let's go that September
10th.
That would be, yeah,
that sounds good. So we'll set it over to September 10th at 9 a.m. That'll be on Judge Hahn's docket. Both are present, and looks like we're. And then Ms. McLean, is your client, Mr. Sendana, on the line?
I saw him earlier.
Yes, I'm on the line.
Great, thank you for confirming that. Appreciate that. All right.
So it looks like Ms. Ewald is also present, the guardian ad litem.
Great, thank you. So we have it was docketed for the final GAL report, and when I checked yesterday, I didn't see that it had been admitted. Has it been filed, or is it still in process?
We've received it by email. I understood that Ms. Ewald filed it. I can't remember which day, if it was last week or.
Oh, okay.
That is correct, Your Honor. That was filed last week at the courthouse.
Okay.
So I've received it.
Okay. Interesting. I think what happened, and I apologize for this. I knew my week was going to be full this week, so I started prepping over the weekend. But even then, it was filed on the 2nd. So, in full transparency, I didn't read it. I had noted in my notes here that no filing of the final GAL report.
And I just assumed I didn't remember that Judge Hahn wasn't going to be here today. She normally just uses these as place markers, and we would be following up with any motions if either of the parties desire to do so. So that was just sort of my anticipation.
Okay, Ms. Swindell, do you have any input?
I mean, I don't really know what's going on. I'm sorry.
Yeah, that's fine. So Ms. Ewald has finished her report, and it's been submitted. And then generally, from what Ms. McLean is indicating, that typically Judge Hahn will then await for parties to file some type of motion based on the information that's in the guardian ad litem report. So that's kind of that would be the next step. So today basically is kind of a marker that the report's been filed. Great. Thank you, Ms. Ewald. And then if either party feels so inclined, then you could bring a motion asking for some type of relief from the court based on that information that's in the report.
Okay. So I need to file a motion then?
If you're so inclined, that would be the next step, right?
Okay. Thank you.
Great. And then anything else, Ms. McLean?
No, thank you.
Okay, great. We'll conclude that, and we'll allow the parties to move forward as they see fit. So today, Ms. Height was appointed on July 2nd, and today was set for a compliance review. And I wasn't quite exactly sure if that was to make sure everybody had filed their information and had been in communication with Ms. Height. So I'll just turn to Ms. Height for an update on your end.
That is correct, Your Honor. I have heard from both parties and received, after some post office glitches, we did finally get the intake packets back, and I've had a chance to set up interviews with both parties, but have not completed both of those. One quick thing I would like Your Honor to address. This case is due for an interim review of an interim GAL report on the 27th of this month. Since that was set, I found out that I'm not going to be able to be here on the 27th, and wonder if the parties would agree, and you would agree, to setting it over to the 3rd of September.
Okay. Thanks for that update, and we'll turn to the parties and hear from Ms. Bliss and Ms. Powers about any of the information that Ms. Height has shared, and if the September 3rd date would work for the interim review.
Your Honor, I was under the understanding Ms. Height did make contact with both Ms. Powers and I late last evening or early this morning, one of the two, indicating that all the parties were in compliance. So I don't have anything to add there. As to the change of the date, obviously I have no objection to changing the date. My only concern is the 3rd is right after that Labor Day holiday. So I don't know what everyone's availability is going to be. I'll be in the office, so I'm fine with that date, but I would defer to the court and Ms. Powers on that date.
Okay, thanks. Ms. Powers?
September 3rd works fine for me, Your Honor.
All right, yeah, I think that seems reasonable. We'll strike the August 27th date and then move it to September 3rd, which is that Tuesday, the following Labor Day, and we'll see everybody at 9 o'clock. And
Thank you.
if the service had
Thank you
been
very much. I
effectuated, and it looks like
appreciate
it had not been. So maybe the parties can give me a status update, see where we're at. Oh, there's also a recusal. Oh, I filed a recusal. Oh,
I wasn't aware.
apparently either was I. So
I just received council's documents yesterday, so I think we need to set this out a few weeks so we can respond.
okay, Ms. Gilmore, timeframes?
Yes, I've agreed. We just received the order allowing service by mail yesterday, so 2 or 3 weeks is sufficient. Whatever Mr. Agnostou needs.
Okay, Mr. Anagnostou, timeframes that you're looking at?
I know I have a week of trial, a week of August 26th, so if we could go into that first week of September.
That would be September 3. Ms. Gilmore, how does that look?
That's fine.
Okay.
I'm sorry, what did she?
Oh,
What-
go ahead.
What did she say? I'm sorry.
I think she said that would be fine. So September 3rd at 9 a.m.
Yes.
All right. So if that works for everybody, we'll set it to September 3rd at 9 o'clock for that contempt motion.
Thank you, Your Honor.
And Ms. Fellows
Thank
is the guardian ad litem. And
Yes, Your Honor.
welcome, Ms. Fellows. And today is the date for a final GAL report, and I didn't see that it had been filed. And where are we at with that, Ms. Fellows?
I requested and talked with the attorneys about setting it over until mid-September.
Okay. So let's say the 17th.
Yes.
Okay. Mr. Zandy? Mr. Zandy, how does that look for you?
That is accurate. We have a bit of discussion about that, and I'm certainly agreeable to the 17th if that's how much time this fellow needs. Sure.
Great. Thanks, Ms. Holder.
Yes, Your Honor, I agree.
All right, great. We'll set the matter over for that final GAL report review on the 17th of September, 9 o'clock. And is Kenneth Anderson
Thank you.
here representing Donovan Day? I see no response there. Mr. Trotter, have you had any communication with Mr. Anderson, counsel for Mr. Day?
Not recently, Your Honor.
Okay, so it looks like it was on today for a motion for contempt, and there I didn't see that there was service effectuated upon Ms. Turner. I also see that there's also an August 27th date set for a contempt motion, which I assume is the same motion. Do you have any insight on that, Mr. Trotter?
Oh, yes. So I think this was the one where we received, the information was quarantined. That's what it was in our email system. So I didn't receive it until way later after learning about it. And I did communicate that to Mr. Anderson's office in hopes that we would be able to seek a continuance, Your Honor.
Okay, so, and it does look like there is a new order to go to court for the show cause set for August 27th. And is that a date that works okay, Mr. Trotter? Okay, and that looks like that was, let's see. Yeah, that's the order that was prepared by Mr. Anderson. So if you're good with that, Mr. Trotter, then we'll just strike today's hearing, just leave it set for the 27th of August.
Yes, Your Honor.
Okay. Sounds great. Let's follow that, and we'll see everybody August 27th on that. James Culver
Great, thank you.
and Ms. Bliss is present. And
Mr.
then Terry Joplin, are you on the line today, Terry Joplin?
I am. Hi.
Okay, welcome to you, Ms. Joplin. And Ms. Corey is the guardian ad litem, and she's here. I can see her. Ms. Corey, can you hear me all right?
I can, thank you.
Perfect. All right, today was set for interim GAL review and the report that has been submitted. I reviewed that, and I'll just hear if Ms. Corey, if you have any additional comments other than your report, and then we'll hear from Ms. Bliss and then Ms. Joplin.
I do not have any further comments other than I would like to be in touch with Ms. Joplin to have her included in this report. It has been difficult communicating with her.
Okay. All right, and then Ms. Joplin, do you have Ms. Corey's contact information?
I do, and I've been emailing her, and I texted her many times, and she said that I wasn't complying with her, and that's not very true. I more or less just ain't complying with the whole I can't pay part because I can't pay. Come on. And I thought they weren't allowed to start their investigation until both parties paid, so I'm a little confused on that one.
Yeah, not necessarily. I mean, the idea is that the court appoints a guardian ad litem to do some investigation, and the court doesn't necessarily want to be hamstrung by parties either with parties not complying and maybe dragging their feet. Not to say that that's what's happening with you, but sometimes that happens, and so guardians are ad litem are given their charge, and sometimes they need to move forward with or without the person's input. And so if people want to participate, then we wholly support that, and we want people to participate and share their information, because that's the more information that we have, the better. So the greater involvement any litigant or party can have with the guardian ad litem and sharing their information and perspective, that gives a robustness to the report. So we'd encourage that further involvement and input. So if you maybe haven't had the full circle hasn't been made as far as sharing your input, I'd certainly encourage you to continue to reach out to Ms. Corey and share that information in timely ways.
Yeah, of course. I wrote her on the 23rd or the 22nd, one of the two, and she said that she was on vacation, and so I waited, and then I never heard back from her. And when I finally did write her again the other day, that's when I got her GAL intake, and I thought that was not very fair. I mean, I'm trying my best doing it on my own and not knowing what I'm doing. So,
okay, yeah, with investigations, having the information earlier rather than later is definitely helpful. As a guardian ad litem investigates cases, sometimes they will talk to people 2 months ago or 3 months ago, and then the report comes out later. And so when information comes late in the game, sometimes it just can't. It's just not feasible to get that information in a timely fashion. So thank you for that input. Ms. Bliss, do you have any input at this point?
I don't, Judge. I did receive the interim report. In her report and recommendations, she requested no changes. My client's comfortable with that. We believe our parenting plan has sufficient safeguards in place for this child, and to hopefully get Ms. Joplin back on her feet and in a good space for her child. I did note that the final report is due on the 13th. I don't know, given the delays that we've had thus far with cooperation and whatnot, I don't know if that's still feasible. So I would just bring that to the attention of the court and Ms. Corey.
Yeah, thank you. So looking at that order appointing the guardian ad litem, that does have those dates laid out. Of the 20th of August is the next report. So this report, the interim report, is a little bit delayed from the anticipated date of July 16th and due to different factors. So we're about 2-3 weeks from that, and so we might want to look at pushing out that final report date 2-3 weeks. Ms. Corey?
Your Honor, I have requested records from DCYF, and they've indicated that those will be to me by the 17th of September. So
okay.
If we could go out after that date, that would be appreciated, so that I could have all of those records available.
Yeah, generally, how are they pretty good in keeping their estimates as far as?
Yeah, if they put it in writing, it's most likely going to happen. So.
Okay. And then turnaround time from if you receive them on the 17th, 2 weeks.
2 weeks would be great.
That would put it to October 1 for the due date. Ms. Bliss, any comment on that?
October 1st works for me, Judge.
Okay. And then Ms. Joplin, any comment on the October 1 review date, basically for that order to be reviewed, or pardon me, the final GAL report to be reviewed?
No, that's fine.
Okay. Well, let's go ahead and then we'll change the final GAL report review, striking August 20th and moving it to October 1st. And then I appreciate you being on the call today, Ms. Joplin. And then it sounds like you've been in contact recently with Ms. Corey, and just encourage that to continue, and that'll allow for your voice to be fully heard, and earlier the better as far as contacting. So, staying in good contact now will allow Ms. Corey to take into account your information and then have that report issued on October 1.
Also, I'm sorry. Also, Your Honor, how might Ms. Joplin ask for the county to pay the GIL fee in this case?
Yeah, that's a very good question. So there was an order appointing, and that order appointing, let me just get to the point, the portion that it talks about payment. So under section 10, it says that it's a private pay, that 50% will be paid by petitioner, 50% be paid by the respondent. If your situation, Ms. Joplin, has changed in that you're not in a position to afford that or the like, you could submit a very simple motion in paper format to the clerk and say, hey, Judge, I'm not in a position to do that. I don't have a job. Or you can kind of explain your financial situation, say, I would like the county to pay for that. So if that's something that's holding you up as far as making payment because financially it's just not possible to pay that, then you could bring a motion to basically change that order that said you have to pay 50%. And if it's granted, then the county would cover your portion. Does that make sense, Ms. Joplin?
Yeah, I had the paper once filed out, and I couldn't figure out how to. I understand. Yes.
Okay. And if you have any questions with that, you could check with the clerk's office, and you might even could check with Ms. Corey, and she might be able to give some helpful insight and the like. And then that would certainly help the process move along more smoothly if that order or if that motion was granted.
Okay.
Thanks, Ms. Corey, for raising that. Ms. Bliss, any additional items you have?
Nothing for me, Judge.
Ms. Joplin, do you have any additional items for today?
I just want to see my son over a meeting or anything. I took the evaluations, and I'm doing the mental health things that James is insisting I'm doing. So, I just want to see Vinny a little bit, anything.
Yeah, that's fantastic. Good to hear that you're getting involved with those different services. I appreciate that. So right now, the parenting plan that was entered on May 7th, see number 4. So it looks like the visitation at this point is supervised and can be up to 2 hours per week. Check with, there's a group called Cowlitz Family Advocacy, and that's who you can. Nope, Ms. Corey's saying no. Go ahead.
It's called Reconnecting Families.
Yes.
Oh, okay. Reconnecting Families is who you'd need to contact. And if Ms. Joplin, if you don't have that phone number, you could probably look it up online, or maybe Ms. Corey could assist you with that phone number. And then that would allow you to have some contact with your child.
Okay, thank you.
All right. Thanks. So we'll see everybody October 1, 9 a.m.
Thank you, Judge.
Bliss represents Elliot
Thanks, Your Honor.
Deutsch, I believe.
Yes,
And-
Judge.
Thank you. And is Brittany Aranivas or Aranivas, are you on the line? All right. I'm not hearing a response from Brittany Aranivas, Arenivas. It's on today for Mr. Deutsch's motion for default and also a motion for an order denying parentage. There is no response to the motion for any of the. No response other than the information that Ms. Bliss and her client had submitted related to there is no born child. And I thought that might be confused with maybe the third pregnancy, right? Because the child in question here is the second, and maybe she was talking about the third child that's forthcoming. Nonetheless, there's been no response to the default nor to the parentage requests. So Ms. Bliss, any further information you have that you want to share?
Nothing from me, Judge. I've never had contact with the respondent. Obviously, my client has provided the minimal contact that he has had with her via text message and email. It's my understanding that she is adamant that there is no child of this name and of this action, so to speak, although I did indicate in her, or I saw in her email that she alluded to the fact that she may be pregnant now, but clearly that's different than the facts that began this matter. My client provided the text messages to you to review what initiated this action, and in those text messages, she told him she had a son. That son shared his name. That son was my client's child, and now, once ordered to provide him for testing, she acknowledges the fact that there was no child born. Confusing as it is and frustrating as it is for my client, he's now asking the court to not only find her in default, as she's never participated in this action, but to find an order denying parentage, just alluding to the fact that there's no born child of this name, of this action, and that's acknowledged by mother. We are asking for a contribution to fees and costs. My client did spend thousands of dollars trying to get this action started, trying to get paternity for a child he believed he had due to the statements of the respondent. So we are asking that our orders be entered as is today.
All right. Thank you. I will order the default and I'll grant that motion. Also, I've signed off on the proposed findings and conclusions and also the parentage order. I'm also signing off on the attorney fees of the $3,260. I think that's appropriate, just kind of given the nature of I don't know, just there was the sense that it wasn't a good time for her to talk about these things right now and the like, and there was efforts on Mr. Deutsch's part since December to get this thing rolling. So I've signed off on those three proposed orders. Those will be filed.
Very good. Thank you, Judge.
This is present, and is Justin Smith on the line today? Mr. Smith?
I didn't anticipate him being present today, Your Honor.
Okay, thanks. All right, and then Deja Bowerman, are you on the line?
It's Shara Bowserman, and yes, I am present.
Thanks for the correction. I appreciate that, Ms. Shara.
Of course, I know it's a difficult name.
Well, that works. I appreciate it. So we're here on Mr. Smith's motion for temporary parenting plan. So I've reviewed the information that both parties have submitted. So I'll hear a brief argument from both. So I'll hear first from Ms. Bliss as she represents the moving party. Then we'll hear from Ms. Shara Bowserman.
Thank you, Your Honor, and as the court is aware, I do represent Justin Smith, petitioner and moving party of this action. He's the confirmed father of 7-month-old Zella in this case. Currently, there's no parenting plan in place. My client provides for you that there has been some obstruction or some barriers placed by Ms. Shara Bowserman as to his visitation with Zella. He's simply just trying to get a parenting plan in place to begin building that bond and creating that father-daughter relationship. The parenting plan that he's provided is a phase-up parenting plan, taking into consideration the fact that she is 7 months old, considering the fact that they don't have that bond and that relationship yet, although he aspires to have that relationship. My client's parenting plan that's proposed has shorter visits for consistently. So we're requesting 4 hours 2 times a week for a period of 4 weeks, then gradually increasing that to 8 hours 2 times a week for another 4 weeks, and then moving into weekend and longer extended visitation until the child reaches age 4. And then we've proposed that the parties share a week on, week off parenting plan. To date, there's been nothing provided by mother nor my client that either of these parties have any limitations as to their ability to parent this child. There haven't been any concerns raised as to any other 191 factors, with the exception I did review in Ms. Shara Bowserman's proposed parenting plan. She's asking the court to make a finding of neglect. I don't think that that's appropriate at this time, especially given the documentation that my client has provided. Mother has provided substantial barriers and restrictions as to his time with the child. And as you likely saw in the text message correspondence, when he did ask for contact with the child, she laid out a list of ground rules, so to speak, for the first meeting. And then most recently said, I need to sit down and think of some boundaries that I want in place. Again, this is mother's continuation of trying to keep control of this child, when my client is simply just trying to have a relationship with his daughter. This is further borne out by her request to restrict him to the state of Washington. him. Again, there's nothing been alleged that he would attempt to abscond with the child or anything of that nature. My client provides that we are a border city. There are a lot of activities in Portland he would love to take his daughter to as she grows up. And I think at this juncture, it's premature to put any of those major restrictions on him and his time with his child. In looking at the proposal of mother, again, very restrictive. She's asking the court to order supervised contact indefinitely. There's no graduation to unsupervised time. There's no gradual progression as to hours and days and the like. She's simply asking the court for, I believe it was 6 hours twice a week, every other week. Again, this isn't conducive to building that relationship. Again, we have a 7-month-old child here. Her needs.
We basically.
Sorry, I muted her.
Thank you, Judge. Her needs are very much of consistency, showing consistent contact with both parents. Most importantly, with my client, who again has had very minimal contact with her for the entirety of her life. My client is asking for his parenting plan to be entered. I don't believe this is necessarily a case for guardian ad litem, but I'll defer to the court if you think that one is necessary, maybe just for structuring of the parenting plan or the phase-up plan. But more importantly, my client is simply asking for time with this child.
All right, thank you, Ms. Bliss. I'll hear please from Ms. Shara Bowserman.
Oh, I agree. I definitely want Justin to be a part of Zella's life. I'm not trying to have this big control factor that it's kind of being visualized to see. She is 7 months old. She has developed stranger awareness. She has stranger danger now. Mr. Smith has visited her for a couple hours. One time, a couple days after she was born, I offered for him to immediately meet her when I came home from the hospital. He responded telling me he was too drunk to drive. I told him, thank you for being respectful and all of that. We set up a date. He came and saw her once. After that, as in my declaration, I've got 21 pages of screenshots of text messages of me reaching out, trying to offer him visitation, trying to get him to set up dates, asking him times that'll work for him.
Ms. Shara Bowserman, I apologize for interrupting. The clerk just notified me that our recording system in court had a little glitch, so we have to kind of pause. And so just kind of put a little bookmark of what you were talking about, and then once we've got that glitch fixed, we'll give you back the forum and the floor to continue.
Yeah, of course.
Just hold tight for a sec. Been resolved. Go ahead, please.
Okay, perfect. So I have reached out multiple times within the first couple months of her being born, trying to find times and work with Justin for him to see her. He agreed. He had 4 days off after the first visitation and after the whole Christmas conversation about bringing her. I'll get back to that in a second. So sorry, I'm a little worked up. I'm trying to find the right words to express what I'm trying to verbalize.
Sure, take your time.
He said that he had 4 days coming up and that he would let me know about it. And, you know, we would plan an actual date and time. He never got a hold of me as the 4 days came up because he told me like about a week and a half in advance about them. I had texted him again, asking him, you know, when he was wanting to see her. He ignored me. I ended up contacting him a little bit later, asking him for some financial help because my maternity leave hadn't gone through yet and I was struggling. My boyfriend at the time stepped up and helped me because Justin had left me on red. Like in the screenshot that I have submitted to you, you can see on the picture, it says the time that he read the message and the date, and he ignored me asking for financial help for our daughter. After that, it went radio silence, and I hadn't heard from him until I got served court papers. Throughout the whole court process so far, I haven't heard anything. I've texted him on Easter, sending him pictures of Zella, saying Happy Easter. All he responded was thanks. Didn't ask about the child, didn't ask to see the child. He did recently reach out and ask about the seeing the child. When I stated that I wanted to think about some boundaries that I wanted in place just for the safety of our child and everything, I was immediately met with, what's the correct word that I'm trying to use here? Conflictive conversation. I hadn't even gone into anything about what kind of boundaries I wanted, whether it was just having someone there so I felt safe or making sure I was there so Zella felt safe. He went off talking about Christmas and how I was being controlling and that this is why he started the court process. Seeing how controversial it was getting so quickly and knowing that this court date was coming up, I did leave him on red and decided that it was for the best interest of our co-parent relationship in the future and Zella's relationship with him, that I just wait for the court date to come up and figure it out with the parenting plan. I am not against Justin slowly being more and more present in Zella's life. The phases that they presented to me did give me a little bit of worry that the pace that they're trying to go at is a little bit too fast for Zella. Like I said, they're trying to start weekend visitations 4 hours on Saturday and 4 hours on Sunday, I believe, from 10 a.m. to 2 p.m. on Saturday and Sunday every weekend. It did not say if I was available, if I was allowed to be present or not. That's the reasoning of my routing for my parenting plan is I just want to make sure that she's not just taken off the bat immediately, because like I said before, she's 7 months old now. She's met him once when she was a couple days old, and she has stranger awareness. So she is going to be in distress. He doesn't know her emotional, schedule or routes that to calm her down and her needs. Sorry, I'm not very good at wording how I'm trying to say this, but for the gist of it, I just want to make sure that she is completely comfortable and safe, and I do not oppose entering a separate parenting plan that we can both agree up on a phase up where it goes a little bit slower, a little bit more comfortability wise for Zella's stranger awareness, making sure that he's actually emotionally developing a good relationship before he just starts taking her. That was my biggest concern. And I did want to briefly mention in his declaration that he recently submitted on my parenting plan, the conditions that caused me not to bring Zella to the Christmas originally. I had stated, because she was only 2 weeks old at this time. She was born on December 14th. It was Christmas time. She was 2 weeks old. I stated that I didn't mind his girlfriend being there at the time. I wanted to personally get to talk to her and know her before she held my baby, or mine and Justin Smith's daughter. I just thought with her being 2 weeks old and that being a complete stranger that I had no previous conversations with before, I was being a little protective. And I did want to make sure that I knew who was going to be around the child and make sure that they were of sound, just stating that it's not a family member and it's not someone who's going to be significantly in her life for the moment as it is. When me and Justin began to not agree on this, I stated that I wanted to bring my grandma, because at this point I was increasingly getting uncomfortable. I was going into a home filled with his family, just me, and that was starting to scare me. So all I wanted was to have someone there for me. She could have waited outside, just been in the car, just a little bit of comfort, knowing that I had someone there for me. And when I brought this up, Justin told me his mom was furious and that I was no longer invited to the Christmas and that we'd figure out a different time for his family to meet and get have interaction with Zella, form bonds and emotional ties. I texted him, I believe, once or twice about when he was wanting to have her meet his family after Christmas had passed, making sure that we were keeping up with that, making sure she meets the rest of her family. He didn't really respond, saying that it was going to be hard for him to find a day because him and his stepdad work together and they don't get a lot of days off together. After that was when I reached out and asked him about the 4-day visit and then the financial help, and was ultimately ignored until the reach out just before I was served this parenting plan on September 11th.
Thanks. Can I ask you a question? Is Zella the first child of Justin Smith? And is Zella your first child? Okay.
Yes.
All right. So both new parents. Okay. All right. Thanks for your input. Appreciate that. Ms. Bliss, any follow-up?
Just briefly, Your Honor, and I understand, obviously we are dealing with a very young child and young first-time parents. My client isn't opposed to, maybe the first couple of visits having mom or having a friend of some nature that Zella is comfortable with to ease in that transition. But again, there's been nothing provided to the court that would require supervised visitation long term. Obviously what's in the child's best interest is having a relationship with both parents, and my client shouldn't be restricted in that sense. So we are asking for a parenting plan to be entered today. Again, I'll defer to the court on the issue if there's a need for a GAL, but that's my client's request.
Can I also add one more thing that I forgot? Sorry.
Sure, go ahead.
At the time of the previous, just a month ago, I stopped breastfeeding. So I just wanted to point out that the time of all of this, trying to meet up and find a place, I was breastfeeding. She was low weight, so it was on demand. I have a doctor's note that I submitted before in my previous court declarations too, stating that she was underweight. Everything I was pumping was going immediately to her, and she was only breastfeeding at that time. She isn't anymore, but I just wanted to add like a previous back face to like history.
Okay, yeah, that's great. Good to hear. All right, well, thank you. I appreciate that. Well, I think it's important to note that, these Mr. Smith and Ms. Shara Bowserman are first-time parents, and that's a magical time and a pretty scary time, and there's a lot of different things happening with new first parents. I get the sense of protectiveness, especially with a 2-week-old. That's completely normal, and it's hard to work these things out with two different viewpoints, and especially when you get other people in the mix. It makes it more challenging for sure. I appreciate the fact that it sounds like both parties are looking long-term at this co-parenting relationship. I think that's really going to be key to the success and the development and happiness of little Zella. So I'm very encouraged by that. I think that the concerns raised here today, it sounds like both parties are interested in making this relationship work for both mom and dad. So the phase-in approach that Ms. Bliss has advocated on behalf of her client, it sounds like Ms. Shara Bowserman is not necessarily opposed to that, sees value in that. It'll develop a relationship for the father. So I think that phased-in process is fine. And then Ms. Bliss has some softening in her client's position, in that there's a recognition of like, yeah, there needs to be some type of transition when this little baby is going to be 7-month-old baby is going to be meeting dad really kind of for the first time, and so there may be some time for transition to get the baby comfortable, 15, 30 minutes, what have you, during those first couple of visits to let the baby know everything's going to be okay. And as that child works through that normal developmental process of the stranger danger or stranger awareness, having that reassurance that mom's nearby and that dad's safe, and then that I think that's good. And it looks like maybe she dropped off and she's coming back on.
I am so sorry. My internet glitched out and I completely lost connection.
That's okay. I saw that you had re-entered into the call, so I was just talking about kind of the awareness of stranger danger in that normal developmental stage, and in relationship to the phase-in process. That kind of that softening of Mr. Smith's position is like, yeah, there's a recognition of like there needs to be some type of transition for those first couple of visits so the Zella, the baby, can be reassured that this other person is safe, and then she can turn to mom for that reassurance or others, maybe 15, 30 minutes to kind of that transition to help her feel comfortable. And, those first couple of visits, they may not go the full 4 hours. They may be a little bit shorter, and dad recognizes like baby needs mom at this point, and so maybe returns a little bit earlier. So there's kind of a degree of reasonability in those first couple of visits and getting things off to a good start. However, overall, I think that phased-in approach is important, and there's no specific things other than what Ms. Shara Bowserman has talked about as far as the non-contact with dad and child. It's an interesting thing because I think with mothers carrying that child for 9 months, there's a bond. You're with that child 24/7, and you give birth, give life to that child, and then breastfeeding. There's that connection. It's really strong. It's really deep. And fathers, their connection, as I've seen, sometimes kicks in a little bit later as fathers get a little bit older, the babies get a little bit older, and they do a little bit more than just kind of look at you and coo a little bit. So it's kind of a delayed connection there, not to say that it's not. So I think because of that and kind of the situation that I've been exposed to and from the declarations of the parties, I'll deny the imposition of any what are called limitations or 191 factors, so that the request for neglect, I'm denying that. I'm also denying any supervised visitations, other than we kind of talked about that kind of that reasonability of those first couple of visits and making sure Zella feels comfortable. There was a request made by Ms. Shara Bowserman related to the child's last name. Recognize that that needs to be sorted out, but I think at this point it's still premature. So I'm going to reserve on that issue. The parties can work on that, and if they can't resolve it, then you can come back to court. As far as the request to take the child out of state, I recognize Ms. Shara Bowserman. There's some definite reticence and resistance to that. I think it's fine to do that because at this point the child is a little bit older, and there just needs to be notice if the child is going to be taken out of state to Ms. Shara Bowserman, so she's aware. As far as decision making, I'm fine with it being joint decision making for education and non-emergent medical care. And then as far as the custodian request, I'm fine that it be set for Ms. Shara Bowserman to be designated as a custodial parent from ages 0 to 3. From age 4 and beyond, I'm going to reserve on that. I think that's, we've got quite a bit of time and development to occur. So I am going to adopt that phased in process that was laid out in Ms. Bliss's motion, which is every week, it's Saturday 10 to 2 and Sunday 10 to 2 for 4 visits for 4 weeks. And then once that's completed, then it'll move to phase 2, which is Saturdays and Sundays 10 to 6. And that would be for a period of 4 weeks or 4 visits. And then phase 3 would kick in. That would be a Friday at 9 a.m. to Sunday at 6 p.m. for 4 weeks. And then phase 4 would then kick in after that 4 weeks has been completed. There'd be the alternating weekends of Friday 9 a.m. to Monday at 6 p.m. And then every week there'd be those 2 consecutive overnight visits during the week. Generally be without specification, but if the parties need something, then it'd be Tuesday 6 p.m. to Thursday at 6 p.m. until age 4. And then phase 5, and this, this is a temporary parenting plan, not to say this is going to be in place until, the child's 18, but then the phase 5 would kick in, would be a week on, week off with exchanges at Sunday at 6 p.m. So there's going to be a lot of water under the bridge between now and then, but that's kind of the course that we're taking. So I think that addressed the issues that the parties had raised. Anybody have any questions or clarifications?
I do have a question. The weekend visits that are 10 to 2, do you think that we could adjust that so that it's 12 to 4? Getting a 7-month-old, 8-month-old up and ready to go by 10 a.m. for anything is pretty difficult. So or at least
12 to 4.
Yeah.
I don't have any objection to that, Judge. I would just add that if we could put the standard or as otherwise agreed between the parties in there, just in case there are events or things that need to be worked around.
Say that again, Ms. Bliss, as far as the timeframes?
I don't have any objection to the 10 to 4 that's being, or noon to 4, excuse me, that's being requested. I would just ask that we put the standard little asterisk that says, or is otherwise agreed between the parties, just to accommodate other events or, any issues that may arise in the future.
Yeah, I think that's fine. It's well taken. So I'm just going to make this a notation here on that proposed order. Because I always think about nap times also with these such things. So
her schedule right now is she sleeps through the night and she usually gets up about 7, 8 a.m. and then she gets changed, takes a bottle and goes back to sleep. And then usually she's up by noon in the day. And that's why I was requesting that, just to fit her schedule.
Okay, perfect. So I think that's fine. So I'll make it from noon to 4 p.m. in phase 1, and then with the asterisk of or as agreed by the parties. So there can be a flexibility there. So with that, I'll sign off on that proposed order. And any other questions from the parties? Otherwise, that will conclude the case.
And so my only question is we're only approving a temporary today, right? Is there going to be another court date set on for actual parenting plans being set in?
At this point, no. So it'll be, you're right, it is a temporary parenting plan. And unless the parties agree to a final parenting plan, then there would be need to have either a trial or some other type of motion to adjust things. And then also, I was just going to make mention, I don't think there's need for a guardian ad litem, so I'm not going to appoint a guardian ad litem at this point. If there comes a time in the future where you feel a guardian ad litem is necessary, certainly either party could bring a motion for the appointment of a guardian ad litem. So you'll be able to get copies of the parenting plan. You can check with the clerk's office, and then you can follow through with that. So
me not agreeing with the parenting plan that they proposed and them not agreeing to my parenting plan I proposed. So the next step would be submitting more parenting plans to find one that we can agree on until the court steps up and just makes one for us? Is that
Yeah,
how
really good.
the process
Yeah,
goes?
really good question. Really good question. So yeah, you're right. There's two competing parenting plans proposed here today. And I've adopted in large part the parenting plan submitted by Ms. Bliss. And so that's the temporary parenting plan, and then you can get a copy of that. That's the order in the case. So that needs to be followed. If any party finds that that temporary parenting plan isn't necessarily working, or there's problems, certainly the parties can work that out amongst themselves. And then if you can't, then you could bring a motion to the court to adjust things.
Okay.
All right.
Okay. Thank you so much.
All right. Thanks.
Thank you, Judge.
Have a
This
wonderful
is
day.
Eleanor Albrecht and Adrian Albrecht, and if I could spell it correctly. And Mr. Zandy, you're representing Eleanor Albrecht, the mother, and then I'll ask if Adrian Albrecht is on the line. Is it Adrian Albrecht? If you're on the line, please make sure you're unmuted and state your name or say good morning so I know that you're here. All right, this is on for Ms. Albrecht's motion for contempt. Looks like prop service was effectuated on the 15th of July.
Correct. And I see that he did file a response of sorts.
Mm-hmm.
Nonetheless, here today, I think it's pretty straightforward on things. Big issue number one is related to that Castle Rock home that the court had ordered back in May to be immediately listed for sale. And you can see from the information from the realtor as well as my client that has been nothing short of problematic. Mr. Albrecht has now taken the position that he's just simply not going to move. He's not going to comply. He's not going to work with realtors. And here we are now in, wow, already almost the middle of August and still no movement on that. Concerned about the market, certainly changing. This is the hot time to sell. And for the last month and a half, we've largely been stonewalled on things. That and the information he gave to us, which said he's not going to be paying the mortgage. But then again, if he doesn't have his house, he's going to be homeless. I mean, so a lot of moving parts that really doesn't add up when you think about the comments he made versus the reality of this. What we're suggesting is that you appoint a special master to this case. So we do need some insight from the court as to who that person could be. I would certainly suggest one of the court commissioners, whether that's Commissioner Carmi or Commissioner Warning, who I believe is still on the commissioner list, or Commissioner Baldwin, or any of those people, I think would suffice to sign on his behalf. Also asking for contempt finding on that, as he has done everything in his powers to frustrate the process, which again, just quite simply needs to happen. My client's concerned about her credit rating. If in fact he does fail to pay the mortgage, which I understand he has. So again, we're put in the cycle of if the house isn't sold, the bank's going to take it, and he just simply refuses to move. I guess that's the first step in this process. If we still have issues with him moving forward, we can certainly address that in future hearings. I'm hoping we don't. I was really hoping he would be here today so the court could send a message to him that he needs to cooperate in this. That's not a choice, it's an order, and move forward on that. That's first of all. Second and third on this again are less emergent issues, but issues nonetheless, and that is related to personal property items. You see the information from my client, and that was specifically ordered in the May order from Judge Hahn. And again, true to kind of form for Mr. Albrecht, he has neglected in giving those. He has neglected and failed to timely provide those or provide access to the home. It's kind of on his terms when he wants to do it. Much better to cooperate when he had an attorney. He doesn't anymore. There's been a lien that's been placed against him from his former attorney. All kinds of problems. This is unfortunately got the earmarks of a perfect storm that unfortunately we're getting out in front of. That's problematic. And then lastly, and we are asking for contempt on that as well in the personal property provision. Lastly is the refund. And again, this was one that was agreed at the hearing back in the spring. We had agreed that they were going to split and cooperate in transferring half of the $6,793 between each spouse. That refund check went into his account. It hit, and we were told that he was certainly going to split that with my client. And again, that was in May. Here we are in August, and he's now saying, I'm not going to give you any of it. Now my client has received it. So I think certainly this is willful and intentional. I think unfortunately the information from the realtor that's attempting to list the sales, the person who's gone out and said, hey, I will help you clean up. I will mow your lawn to put this on the market, and is getting met with resistance and allegations that he works for the government and he's part of the grand conspiracy plan and all this other stuff. Something needs to be done. I think at least getting the contracts and the listing agreements signed would be the first step. I would ask for the special appointment of the master on that to sign on his behalf. And I think we go from there. As far as the fees and sanctions, I do think those are appropriate given the circumstances. We would ask and that be taken out of the initial proceeds off the top that was awarded to each party. Each party gets $20,000 for this. That is certainly enough. And this is an individual who's well employed, has a good history, he's well trained, just refuses to work. And this has been recognized by the court in May. $20,000 with a person who can make upwards of $70,000 a year is plenty of money to get restarted. And he just, again, simply refuses to do that. Any award of fees and costs that we do ask come off of his $20,000 that is otherwise earmarked for both parties upon the sale of that house. But at this point, we just need to get the thing listed and get these parties on with life, and recognizing the fact that this is what happens in a divorce. You got to split the assets, and he just refuses to do that.
What was the amount of attorney fees you're requesting? I had noted 1,000, but I wasn't sure if that was accurate.
$2,000 on the attorney's fees portion of that.
Okay.
I'm sorry, $1,000 on the attorney's fees portion of that, and we're asking for whatever you do for a civil sanction also come out of that.
Okay. All right.
And I would suggest $250.
All right. Thank you.
May I say something, please?
No.
I'm looking for Adrian Albrecht. Is Adrian Albrecht on the line?
No, this is Eleanor Albrecht.
Okay. All right. Thanks, Ms. Albrecht. So with regard to the motion for the appointment of special master, yeah, it seems like there's a clear unwillingness on Mr. Albrecht's part to not cooperate as ordered by the court. And especially then when you get this kind of this government agent conspiracy type mindset, it's very problematic. So I will appoint a special master. That'll be Commissioner Jill Carmy. She can sign all paperwork related to the listing and the sale of the property there on Sandy Bend. Then also I'll make a finding of contempt for the removal of property items that was prohibited, including the massage chair, the pressure cooker, the power tools, garden items, the bank machine, and the like. As far as the tax refund, I'll make a finding of contempt there also for failure to provide the 50% of that to Ms. Albrecht. And then I will I will award $1,000 of attorney fees, and those fees can be skimmed off the top of the home sale proceeds. Same with the $250 civil penalty. That can also be skimmed from the top. And I think that addressed the items that were requested or raised in the pleading. If I missed anything, Mr. Dandy?
No, I believe that's good. And I will discuss with my client. Since he's not here today, what she wants to chime in with, I can certainly present that to the court when the time comes. You want to present an order ex parte, just mark that he was not present for the hearing?
Yeah, that would be perfect. Thank you for doing that.
Okay, I'll get that over hopefully by this afternoon or tomorrow sometime.
Ms. McLean is on the line.
Right.
She's representing Britt. Is it Bosick or Bosick?
I understand it as Bosick.
Bosick, okay. And then Ms. Winkles is also on the line. She's representing Ann Bosick. And are either or both your clients present, Ms. McLean?
My client is present and identified as Noelle McLean client with my photo.
Very good.
And I'm not sure if my client is here. She's in Mexico, so she was having trouble getting on earlier.
Okay. Ann Bosick, are you on the line? Ann Bosick? Okay, looks like she's not. All right. We're up today.
She is present.
She's here. Okay, great. All parties are present. Very good. All right. This is a motion brought by Mr. Britt Bosick. That's why I misspelled it. That's why I got mixed up. Okay. So it looks like so this is related to some spousal support and some property items and credit cards and debt and the like. So I will hear from Ms. McLean, and then we'll hear from Ms. Winkles.
Thank you. So we have before you a long-term marriage at 33 years. It is acknowledged that these parties separated approximately 2 years ago in August of 2022. And prior to their separation, both parties had retired. Ms. Bosick had separated in 2020, and my client had separated in September of 2021. Our position is that given the fact that this is a long-term marriage, that while we ferret things out through the court system, that the court should be focused on placing both of these folks in a fairly similar financial position moving forward, and also to preserve as many of the financial assets that still remain for the court to be able to divide in the future. As you saw in the documentation, we filed both under seal as well as provided information in my client's declaration The parties did sell their home in Kalama, Washington, prior to their separation. At that time, they received a net of $761,663. And since that time, Ms. Bosick has essentially had free reign of those funds. One of the concerns is that initially she purchased a home with a portion of those community funds in Mexico for $300,000. My client tells you that she then sold that at a profit for $399,000, and then she turned those funds into the purchase of a second home, of which she's also expended community funds to make improvements to that home, including building a pool. At this juncture, we've not been provided any documentation tracing any of those assets as far as how much was spent on the purchase of the first home, the settlement closing statement on the sale of the first Mexico home, the purchase of the second Mexico home, and the like. But clearly, our expectation at this point, and the fact that counsel has represented that she's appearing from Mexico, is that she's residing in the second Mexico home that's free and clear because of the purchase through the community proceeds. So if we take that at face value, then the question is what of those proceeds are left that we at least know of at this juncture? And how do we deal with that in conjunction with Ms. Bosick's request that the court order that the Kalama home be sold? So first off, our position in regards to Ms. Bosick's request on selling the homes is currently they're both in a home that's free and clear, that's been paid with community funds. So there is no reasonable reason, there's no reason for them to have to sell these assets at this juncture and displace them as far as housing. They'd end up having to pay for housing, where right now they both have minimal expenses as it relates to housing because there isn't a mortgage affiliated with either of these homes. My client has been primarily in the Kalama homes since their separation 2 years ago. Ms. Bosick has been in Mexico since their separation 2 years ago. So our position is that court should deny Ms. Bosick's request to sell the Kalama home. If you are inclined to order the sale of the Kalama home, then the court should also order the sale of the Mexico home. But again, I think that that's unrealistic given the current financial circumstances for both of these parties. And I think that that's an issue that should be ferreted out after we have complete discovery and the trial court can make a determination whether or not that's in these parties' best financial interest given their current situations. In regards to the personal property and the vehicles, my initial reaction was that there wasn't an issue relative to vehicles. Ms. Bosick tells you that she sold the Nissan Juke. Obviously, we're going to need an accounting relative to that issue, as well as the homes. And we have included in my proposed temporary order the issue on the, on the tracing of the home sale proceeds from Kalama and how those were spent and whatnot. You'll see those in paragraphs 14A and 14B of my proposed temporary order. We were unaware that she had sold the Nissan Juke, so obviously there should be some accounting as it relates to that vehicle. I have no idea why she's proposing that the Hyundai be returned back to my client. That has been the Hyundai 2022 Hyundai Kona. That's been her vehicle all along. And my proposed temporary order has her receiving that vehicle. So we would propose that, if anything, there be an interlineation at our proposed paragraph 7B that just indicates relative to the Nissan Juke that she should produce tracing as it relates to the sale of that asset and those proceeds. In regards to her request as far as personal property, my client outlined for you his willingness to arrange through their son that for her to receive her jewelry, her grandmother's paintings, her clothing and shoes, her antique china, the Christmas decor, and her separate photo albums. Obviously, if the court wants to interlineate that, you could simply make reference to my client's declaration outlining those items that he's agreed to arrange for the son to retrieve from him and deliver to her. And certainly, if counsel has any other issues relative to personal property, I'm assuming that she'll shoot me an email and we can try and cooperate in getting that arranged and accomplished. But technically, it was my client's understanding, since she had free reign for 2 weeks prior to their separation, that she had removed all of her items. But clearly, we'll follow up with that. In regards to Ms. Bosick's claims for a restraining order, I would submit that there is no substantial evidence, there's no factual evidence to support her bald assertions. You have no police reports, you have no medical records, you have these parties separated for the last 2 years, and there's no text messages or emails or anything that suggests that my client has acted inappropriately, that he has assaulted her, that he has threatened her. And you saw in his reply declaration where they had originally had an initial separation in 2021. He went down to Mexico for a couple of months. They were trying to reconnect or rekindle their marriage, which unfortunately was unsuccessful. He came back here, and then she came back up here for a period of time. And then they had the final separation in August of 2022. He didn't prohibit her from removing assets. And again, there's absolutely no evidence to support a restraining order. So we would ask that the court deny that request. You'll see that she had also, at least the way she described this attack dog, I think that the photo sheds light on sort of the veracity or her credibility. Certainly, my client indicates the dog didn't care for him, but not an attack dog, clearly a lap dog, and not something that has ever occurred. This dog has not threatened him, and he has not threatened her. So we're asking the court to deny those requests. In regards to the finances then, first off, my client tells you that Ms. Bosick has controlled the financial purse strings since their separation. She has controlled my client's phone and the passwords and access to his personal accounts. We do ask that the court interlineate language in the temporary order that Ms. Bosick is to provide all of his passwords and relevant information so he can access his accounts and his photos, because at this point, it's his belief that text messages and photos have been removed from his cloud, and he needs to be able to have access to that cloud. Financially, there's this whole argument about Bank of America number 4321. That is a credit card. Ms. Bosick makes these claims that my client has removed, $36,000 from that account or from the community account in order to pay that account. If you take a look at my client's credit report that we produced, you'll see that there's 4 Bank of America accounts, 2 of which have been closed. One of which is affiliated with my client's bank account, and there's been minimal to no activity. Actually, there's been no activity over the last 3 years, such that Bank of America was unable to print or provide any statements because there's been no activity. And that's supported by the credit report that we provided. The difficulty as far as the credit report is that it masks the last 4 numbers for security. And so I did under seal provide a photo of the back of my client's credit card that is affiliated with the joint credit card that is this 4321 account. So you could see that all of the numbers match up in the credit report. You'll see in the credit report, my client is an authorized user. As an authorized user, he does not have the right to access statements. It is Ms. Bosick's primary account. She is the only one that can access those statements. And here she makes claims that, my client needs to do all of this. He's attempted, he's been denied by Bank of America, and the credit report clearly shows this is her account. So she has access to all of these records. She's not produced these records. And she makes these claims that are not supported by the documentation. So if anything, she's the one that needs to produce these records. And at this point, it appears that it is in fact Ms. Bosick who has been the one to remove $36,106.81 from the joint Bank of America account to pay that credit card debt. Mr. Bosick does tell you, again, because Ms. Bosick was the partner in the relationship who handled the finances, that she instructed him that he was to use only that credit card for purposes of expenses. And he complied with her request. And so at this juncture, she does need to produce those records. My client tells you that he has not hidden or transferred any funds. We did produce his separate bank account where you can see his Social Security that goes in and his expenses that are paid out. He also has use of the joint bank account number 1340 that as of mid-June had $64,254 in it. Ms. Bosick has the Wana Federal Credit Union and PNC accounts that appear to have at least $119,201 in those as of the most recent statements that were provided. She states in her declaration that she transferred funds, from the Columbia Bank account into the PNC account. And I assume through discovery we'll get proof of that. If you take a look at our sealed financial source document that was filed, I think it was July 2. Yes, on July 2. The tax return, the most recent tax return is 2023. The tax return for 2023, if you look on page 4 of that sealed financial source document, well, I think given the cover page for you, I think it would be page 6 of the PDF, but it's identified at the bottom of the page as page 4. It seems to identify, as far as bank interest, that there's a Bank of America account and a PNC Bank National Association, and there is not identified a Columbia Bank account, so that would seem to support that suggestion. Again, we'll just want to see those historical records, though, and we'll again get that through discovery. But you can see that the PNC Bank account had annual interest in 2023 of $5,326, and that's significant, and suggests that there's a significant amount in that account without knowing what kind of an account that's in or what kind of interest rate. I don't know if that accounts for all of the $119,000 that we've seen in the bank statements that have been produced. The bottom line is that in order to equalize these folks right now, just on bank accounts, my client has the $64,000, she has the $119,000. We're proposing that the court interlineate in the order that she transfer $55,000 into my trust account for safekeeping. That will leave them both with about $64,000 moving forward to supplement their income and the like. In regards to incomes, currently my client's only income is his Social Security. His gross is $2,132 per month, and we've provided that both in his financial declaration and in the sealed documents, and it's also supported in the bank statements that have been produced. Ms. Bosick receives a gross of $2,595 in Social Security. And historically, and this is as of 2023, again, if you look at the tax returns, she was receiving $2,083 from her IRA, and then another $625 from Millennium. She claims that those have now been zeroed out. I'm not certain that I have received sufficient documentation relative to that. So as far as I know, she's receiving that additional about $2,700 a month, which would put her at a gross of $5,303. In order to put them into equal parity, then she should be paying my client the $1,450 per month of spousal support, and we'd ask that start July 1. We've outlined as far as within the proposed temporary order that my client would pay the Kalama homeowners insurance, property taxes, and the like. I guess arguably the wife should be included as far as paying whatever expenses there are affiliated with the Mexico home. And then we had very limited information on all of these credit cards for Ms. Bosick. She should be responsible for whatever those PNC visas are, and the Bank of America Visa 4321. Again, as we've shown that's in her separate name only. I'm sorry, that she's the primary, not in her separate. She's the primary, but he's an authorized user.
And with regarding, you asked for an accounting related to the Mexican home, correct? The Mexico home.
The homes.
The homes. Okay. And then more precisely, pardon me, is that the 761,000 that was the sale proceeds from the Kalama home, you were asking for an accounting related to that. I just had a few questions on that.
Sure.
So when I was looking at it, it looks like, at the time of separation, Mr. Bosick received 129,000 roughly, and it looks like Ms. Bosick received roughly 257,000 kind of in cash, the different bank accounts that they were kind of working out of. And then there's 300,000 additional dollars that were used to purchase the Mexico house. And that when you add those up, that comes up just about to $680,000. So my question is, if we know that if we work off of those assumptions that Mr. Bosick had 129,000 to work with, and Ms. Bosick had about 250,000 plus the 300,000 at the Mexico home, that puts us just shy of the 700,000. So there's about 100,000 that's kind of murky. How important is that accounting at this point with discovery ongoing?
For purposes of temporary orders, I don't know that is, but certainly it is important as far as tracing what's happened with the Mexico proceeds or with the proceeds that went down to Mexico. So the assumption that she had 300,000, my client tells you that he was advised that she sold the first Mexico home for almost $100,000 gain. So that would be community gain. So her 3,100 in the house has now grown to 399,000. She then puts that into a second Mexico home. We have no idea what she's purchased that for. We know that she's also used monies in order to upgrade that to build a pool. So we'd like to see those accounting so that we know if there's other money out there. So I think my client's entitled to see where those are, and if there are additional proceeds, that those should be deposited into the trust account, again, for the court to dispose of in the future. The starting assumption, as far as I think you said, 129,000 to him. Again, keep in mind, Ms. Bosick's claim was that my client had drained $36,000 out of that community account towards this 4321 charge card, which is her charge card. She's the one that has removed those monies from the joint account in order to pay that charge card. So his 129,000 now goes down to, what would that be, 86,000, if I'm doing math appropriately backwards. So, I mean, there's a lot of moving parts out there, and I don't have complete bank records at this juncture. That's why I'm asking for a tracing of this. It would be the settlement closing statement on the purchase of the first home, the settlement statement on the sale of the first home, settlement closing statement on the purchase of the second home, and then to see where those other funds went. It does sound that at the beginning, when the Kalama home sold, that they did pay off some community debt, because at that point, neither of these folks had vehicle debt, had credit card debt at that juncture. And then we have these home purchases.
Okay, thanks. All right, we'll turn the time to Ms. Winkles. Ms. Winkles. It looks like the mute button's on.
Yes, Your Honor, my apologies. I represent the wife in this case. Ms. Bosick, she fled the marriage due to domestic violence. And we can see that because she essentially tells us what happened. And we need to not look for the red herring of the dog, because the dog, if you read her actual declaration, she doesn't call the dog an attack dog. She says the dog jumped in front of her, baring his teeth and growling, causing him to back off. A little dog can do that. In fact, lots of little dogs are more aggressive than big dogs. The fact is she never called it that. And we need to focus on what she actually states. She says he never hit her. And domestic violence, as we know, is a lot more than assault. She was afraid of him. He was an alcoholic. The police were called out to the residence twice due to assault against a neighbor. Is there a police report? No. But there's a lot of times not police reports in domestic violence. And to say that something doesn't exist because nobody called the police in a domestic violence situation is frankly ridiculous given what we know. What happened was my client states that he was an alcoholic and that he essentially was going to lose his job due to drug use and alcoholism. He retired early. They both agreed for him to do that so that he didn't get fired and lose his benefits. One day where he was particularly drunk, he got in her face. He scared her enough to where she hid herself in the fifth wheel, waited for him to go fishing, and then she left. And she took as much stuff as she could put in her car and she drove to Mexico. She never came back. And the fact is that she's had almost no contact with him since then. She states that she sold the first house to get away from him. She didn't make a gain on it. She lost $50,000 because he found the address and he made comments to their son that he was going to go down there. So she sold the house and moved into
Where
another
I'd
place.
object this to hearsay.
The objection is noted, overruled.
Fact is we can also tell that this was due to domestic violence given what she did. And what she did is she split the parties completely in half. So we'll see that in the joint account, she left him $128,000, and that's under our sealed Exhibit A. You can see that that is the amount left in the joint bank account, Bank of America 3875. She never used this account again. We can tell because if she were to use the account in Mexico, it would show up as a Mexican charge, and it doesn't. You would have it go into pesos, and then you'd have it translated. We don't. If you look at the statements that we supplied, every single one of those is from our area, which means she didn't use it. Now, the credit card is also kind of this interesting thing. My client has had trouble getting it. I now have them. Unfortunately, I can't put the statements in today. I got them yesterday. But the fact is my client has not used this card since 2022 when she left. I believe there were occasional charges from a Nintendo for $4 for 3 months, and those were canceled. She never used it again. In 2023,
I guess I would object as to counsel's argument on records that are not before the court and that I and my client haven't had an opportunity to see.
She states in her declaration that she has not used that credit card at all.
That declaration stands as far as an argument based on any documents that haven't been shared, all is sustained.
Okay. She's not used that credit card at all. That Mr. has completely been the one in charge of that credit card. And although an authorized user, that's the credit card that he uses. And the payment for that comes out of the joint account. The fact is that she separated these parties and put them into an exact equal position. So he had the Kalama house. He also had his truck, which she states, his toys. She talks about all the toys. The toys on their own are, she talks about the RV and all these things. The toys come up to over $150,000. And she mentions that that's what he did as soon as they got this money. He went out and bought all these toys. And he still has them. And we'll supply the VIN numbers. We'll supply all of those things in discovery, which is what we do normally. What she did is she took a relatively small amount of money and used the majority of the money that she took to buy the house. So if we look at them on if we're looking at them side by side, Mr. has 125, she takes 300, about 300 or 250. And what she also does is gives him the entirety of her retirement. So she gives him two different retirement accounts. The first one is the WANA Federal Credit Union 401k, which is $45,855. She gives that to him. That amount goes in. You can see it going in. We submit that as well to your honor. I believe the Millennium one is Exhibit C. I believe other 401k is Exhibit D of the sealed documents. Or no, sorry, Exhibit E. She gives him these come out, and we can see that he's using this every single month. So the first one, the Millennium, 2,000 came out, 500 went to taxes. He uses this every single month, and we can see that in the banking statements. My client doesn't use this. He uses this. We can also see the amount that it started at because we put that statement in, and we can see that it had a balance of about 50,000 at one point, and we can see it completely go down to zero. So then what she does when the 401k is exhausted, he's spent this all. So he has now run through huge amounts of credit cards. He's also run through her entire Millennium 401k. She's still worried he's going to find her. She wants to keep him comfortable. So she gives him the WANA Credit Union one. That's also 50,000. It had a market value of on July 1st, 2022, the month before she left, of 47,000. After withholding taxes, 2,000, about 1932 a month, starts going into the joint account for his sole use as well. He's been using that every single month. So as of November, he's been getting Social Security, about $2,100, but he's also been spending the $1,932 that's gone into the account. He has now spent over $30,000 of that retirement. As Exhibit H shows, June of 2024, that account has decreased in value to $16,000. We can see the corresponding bank statements to see that every month it's going in there. We can also see on those corresponding bank statements, every month it's being taken out for Mr. Bosick to use. And we can clearly see that it's him using it because they're all taking place in Cowlitz County. None of them are in Mexico. So again, to kind of backtrack, he has a house that's worth over $200,000 that's free and clear. He had $125,000 in the bank. He had $45,000 from the WANA Federal Credit Union. He had over $30,000 from the Millennium Trust. He had his Dodge Ram, and he had all these toys worth $150,000. The Polaris, the boat, the fishing stuff that she talks about. Now, what she had was the Columbia bank accounts that had about 115,000 in it, I believe. And then she had PNC, which only had about 18,000 in it. So whereas Mr. has blown through over $200,000 almost, Mrs. has been very, very good and very conservative and still has 90,000 of the original amount that she took left. These original amounts were almost equal. So where now he comes, he's blown through he's spent his every month, he's spent her retirement, he's spent his equal share that he received at the date of separation, he spent. And now he comes to her and he wants the 90,000 that she has. Now she took 150 and she has 90 left. And now he wants that. She has a house almost of equal value to the house he's in now, and we'll provide those. We have those as of today. But she states that the house she's in is pretty much the same value, and it really is. And so now he comes and he wants spousal support on money he's receiving into the account. So that right there is a credibility issue of Mr. because he's saying, I want this is what she's getting, when he knows full well money doesn't magically appear in the bank account. So he's getting this money from somewhere. He's getting it from her. He's spending her retirement, and yet he wants her to pay spousal support, claiming that she's getting that retirement. It's just an attempt to kind of pull the wool over the court's eyes. And on top of that,
can I ask a question?
Yeah.
Regarding the WANA 401k, so which started at 47,000, it's down to about 16,000. Is that 2,000 roughly a month? Is that still going to?
It is.
Okay.
Yeah, so it's still going into the joint account that Mr. Bosick's using, and that's at Exhibit H. You can see the decrease in value, and on Exhibit F, you can see the initial value. And then on the bank statements, I believe they're Exhibit G of the sealed, you'll see it actually going into that joint account, and you can see him spending it.
So his net income right now is about, Social Security plus that is about 4,000.
It's about 4,000, that's right. And my client earns a little, I believe her net is 2,400 with her Social Security. So he has considerably more to live on than she does. And again, he's spending. The fact is we don't know, we don't have, well, now I have those statements, but according to her, just adding them up from how much came out of the joint account, in 2024, he'd already transferred $36,000 from the joint account, or I shouldn't say he transferred, it might be automatic, we don't know at this point, but they'd already transferred that to the credit card to pay off a credit card debt that he incurred. So we see that he's using this credit card, spending his money and coming to her for more money. She's willing to give up the car. I don't believe she drives. So that's why the car was included. She doesn't need the car. It's a brand new car. He can sell the car. She can have it back to him. He has a lot. He has a 2016 Dodge Ram, 2018 fifth wheel, jet sled boat, and she's willing to give the 2020 Hyundai to him. He has about 25,000 in fishing equipment. The tools she thinks are estimated about 50,000. I guess he has Snap-on. If you add up all of those into an Excel spreadsheet, you'll see that Mr. has actually come ahead of her by about $100,000 over the course of the separation. And she's okay with that. She did that on purpose because she wants him to not be able to find her. She is incredibly worried about that. She would like her address kept confidential. She's applied for the confidential address program. We don't have I believe she applied through one of the I don't know what they're called, you can't just apply for it online. You have to go through one of these agencies. She's done that. She does not want her address disclosed to him. That's why she sold the first house. My client, other than the Social Security, has nothing else. There's 90,000. There's nothing else. That's it. That's what she has to live off of for the rest of her life. My client was the breadwinner in the marriage. My client was the one who didn't control the money. She was just better with the money. She's able to save, whereas Mr. isn't. That's all she has is 90,000. There's nothing else for her. She can't go back to work. She retired. She's retired. She lives off her money in a very frugal fashion. He doesn't. And it's completely unfair and not equitable at all to allow Mr. to buy all these toys and to spend since they separated, and then to come to her and ask her as well in the last few years. And she hasn't done that. And to punish her for that and to take half of that away and give it to him, somebody who's bought all these toys on a limited income, he still bought all these toys, is not fair. If we're really to put them into the same position and to equalize the parties, they were equalized in 2022. they still are equalized because he does have all of these assets there that put them into the same position. He has, a $35,000 car. He has, a $28,000 RV. The fact is that when you add up what he spent his money on, the money's still there, albeit in a different fashion. They're already equalized. Discovery is really the mode that we should be doing rather than asking for an accounting. It seems really premature. This was filed on June 28th. My client was in Mexico. There was an order to serve by mail that was signed, and she was served by mail, I believe, sometime around the beginning of July. The fact is we haven't even hit the 60 days for mail yet. That 60 days wouldn't hit until August 27th. So this entire thing is premature. Now I've come on to the case and we've answered the response, and we've given a very fair itemization on exhibits A and B, a distribution of the assets, which equalize the parties and still put him in a better position. But for an accounting, it seems unfair when the money went into the joint account. So the money from the sale of the house, if you look at those sale documents, went into the joint account. Mr. needs to go back to the beginning and look at his joint account. He's a named holder on it. But they've asked for discovery. We have completed it. We have it. We're going to give it to Miss McLean's office tomorrow. Hopefully it will account for everything minus some of his credit cards that we didn't know existed. The question, though, becomes about that second house. Can we redact the address? We can submit everything else, but the address.
Well, Your Honor, I guess I would object at this point. One, that's not a motion before the court. Counsel and I need to engage in a CR 26I on discovery issues before we come to the court and request relief.
So is there any objection to protecting the address of the second home? Maybe with some type of identifier that everybody knows what it is, but not sharing the address?
So how am I supposed to be able to value this home if I don't have an address to be able to send somebody down there to value it? How do I get an expert down there?
You wouldn't be able to anyway. It's under the laws of Mexico, and they don't allow, you can't get somebody to value a place in Mexico with any order from the United States. So that's the fact that my client's even here is, shows that obviously she's completely willing to work through this, but she's afraid, and she has filed for the confidential address program.
Okay. All right. Thanks for the input.
And so, Your Honor, my client is asking that the parties be left as they are on the temporary basis. We will supply Ms. McLean with all of the discovery that we have. We have all the credit card statements. We have the bank statements. We have everything that pretty much that they've requested that we're able to get. And it would seem appropriate to do any tracing in that discovery and not put any more onerous orders on my client that she's unable to comply with, being that she's in Mexico. Additionally, we can ask for no spousal support. My client's not even asking for spousal support. She said that, as she stated in her declaration, if we're really going to equalize them, then he should probably be paying her spousal support of about $1,000 a month. But she's not asking for that. She just wants to separate, and as she did a few years ago, go about their separate ways. No spousal support on either side. Both parties keep what they have in their possession now, although my client will return the car, and that her address remain confidential. Other than that, Your Honor, if Your Honor is inclined to start selling things and start putting money into trust accounts of attorneys, then really, if we are going to do that, then his house does need to be sold because my client has the money in the bank, but Mr. has all these toys and has the house. So if we're going to put the money in Miss McLean's bank, we also need to put an equal amount from his estate into the bank as well. And so we'd ask for either the house to be sold, which would be easier, or some of his toys in the equal amount as to what goes in her account for my client.
Thanks. Does your client have any objection to the passwords as far as the photos and text messages?
And that's the thing, that was in their SIR reply. So I was able to get a declaration from my client. Obviously I didn't file it, but that was new information. My client doesn't have that. So what happens is he was using her Apple account on his phone at some point in time. When they separated, she obviously changed the password to her Apple account. It wasn't his Apple account, it was hers. And when she was seeing all these phishing pictures, that's what they were coming up on her phone, she was deleting them and then disconnected her Apple account completely from any device that it was on. But if she were to give the password to that, and we do have text messages from him that are, I won't say, well, they borderline abusive to her about the passwords. The fact is she can't give that to him because that's her Apple account in her name, her email, the whole thing. He needs to get his own Apple account. She can send what pictures she still has, But I believe she's deleted, they were mostly phishing pictures. I believe she deleted them every time she saw them on her phone, because she would wake up and there'd be 100 phishing pictures. If she has any on her cloud, we can definitely put those on a CD or a Dropbox and send them to Ms. McLean.
All right, thank you. Ms. McLean, I'm sure you have some comments on rebuttal, but I just wanted to ask you, as far as your clients' income levels, as far as your client's view of Mrs. Bosky's income levels, she has the 2,400 in Social Security income, and then she has 2,000. You represented about 5,400 of net or gross income on a monthly basis. Tell me where that calculation, what it's derived from.
The 2023 tax return, which was what I had at the time, and that's filed under seal on July 2.
Okay, so it's the 2,400 of Social Security income, and then break down the other two figures.
So if you look towards the back of that, you will see the standard insurance of $22,500 gross for the year, and the Millennium Trust Company a $7,500 gross distribution for the year.
Okay. All right, and that Millennium, it looks like the representation that it's currently depleted. But you're not sure about that.
It's possible. I'm not certain it's possible.
Okay. All right. So it's the 2,400 Social Security income that Mrs. has, and then.
So I understood that her gross was 2,595. What hits her is net. So.
Yeah, and then you were looking at the 22,500 of the tax return as that being pensions and annuities. That 22,500 is the additional 2,000-ish.
Yes.
Okay. All right. Thank you. So thank you for that. I'll give you a few moments for rebuttal.
So basically, what I would acknowledge is that if you look at, and this is paragraph 7A, these toys, council and I haven't had assets valued yet, obviously, but all of those assets are, as far as the vehicles, are older. Only Ms. Bosick is the one that had a new vehicle at the time of their separation. She had a 2022 Hyundai Kona, which my client does not want. That should remain with her. He does not want that vehicle. So at this point, all of his vehicles are older, much older. I mean, he's got a 2003. His most recent vehicle is a 2018 Polaris ATV. So those were all purchased well before these parties separated. Those were community decisions at the time. And obviously valuing those are things that we'll need to do as we move along through this action. We do think that it is very important for an accounting, and again, providing the settlement closing statements or comparable documentation as it relates to the value of these houses in Mexico, or what was paid and what was earned off that sale. Clearly, counsel in her representation as far as assets for her client ignores the fact that there is this house down there that is worth more than what she originally paid for the first one at $300,000. So in regards to assets, bank accounts should be equalized at this point. We'd produce the documentation that he had about 64,000 as of mid-June. If you keep her in the same amount, then she's transferring based on what she had at the time. She would transfer $55,000 to my trust account for safekeeping or safeguarding for the court to determine further on down the line. And then from that $2,000 a month that she's pulling, or I think it's $2,500 a month that she's pulling from the standard insurance, then my client should get $1,450 of that, and she would get $1,050 of that, and that would equalize their incomes in relationship to the Social Securities that they have.
And Mr. Bosky, his Social Security income net is around 2066, and then is he still receiving the WANA 401k distribution? Is that still coming his way?
I don't know the answer to that. That's totally up to Ms. Bosick. She's in complete control of that. So if that's historically, I believe that was deposited into account number, into the Bank of America account. I think the 3875 is the community one.
Yeah, I think that's right. 3875.
No, that's his separate one. Oh, no, that is the community one. So yes, that was going into the community account.
Yeah, okay.
19, it looks like $1,932.50. That's what was deposited on March 25th.
Okay. All right. Thank you.
Your Honor, can I just make a brief statement?
Sure.
Okay. If you add up what they actually got at the date of separation, and I've added those in, well, my clients added those, I don't do math. On page 4, she adds up what Britt had at the date of separation for $426,000 in assets. If you add up hers at the date of separation, it was $257,453 because the funds were used to buy the house. So the funds she took were used to buy the house. There were additional funds that she did get from a third party, but she sold for a loss, and we will provide those to Ms. McLean. But those figures are all in there.
Thanks.
And I would just dispute that because she's including the value of the home to my client, but not including the value of the home to her client. So, and again, those are all things for final. That's not appropriate for temporary orders. We're looking at what's liquid right now and how do we preserve assets so that the trial court, once you do have all of the information, can make a fair and equitable distribution of assets to us.
Thank you. Thank you both very much. Lots of numbers swirling around, lots of different documentation, lots of accounts, and 33 years of marriage to boot. So as far as the first issue I wanted to address is the current Laverne Road in Kalama home, as far as selling that or not. The answer is not. No need for either party to liquidate homes that are paid for and that provide safety and security to both parties. The next item is the restraining order. The restraining order is interesting to me in that I don't have a lot of information. I have the information that Ms. Bosick supplied related to the alcoholism and fear and the conflict with the neighbor, and then the episode where the dog stood in between the two of them. What I know from between then and then now, there was an alleged period of time where there was maybe some reconciliation efforts where they were sharing time together in each other's respective homes. So at this point, I'm going to hold off on the restraining order and not impose that. Obviously, I recognize Ms. Bosick has some big concerns, but I think at this point there's just insufficient evidence to support that. The issue related to the passwords and the text messages and the photos, if it's an iCloud account, that's opens up a much larger can of worms. An iCloud password gives you greater access to just more than photos and text messages. So I'm going to reserve on the password issue.
Would the court order that she not delete any items at this juncture?
Yeah, I think that seems reasonable. Any concerns with that, Ms. Winkles?
No, we would hope that he'd have his own account at this point in time, so there shouldn't be any new ones coming, but my client won't delete anything else that's in there.
Okay. That'll be part of the court's order, that there's preservation and non-deletion of items that are within that iCloud account. Then the parties are largely agreed as far as the jewelry, with the caveat of that the granddaughter Ava has the jewelry box. That the jewelry should be returned to Ms. Bosick. And then the grandmother's paintings, the clothes, shoes, purses, the antique china cabinet, the Christmas decorations, and decor. Those should be returned to Ms. Bosick through their child. I think Luke was his name. Then as far as the photo albums, that's a little more difficult at this point. There can't be just a kind of a wholesale turnover of the albums. There needs to be copying done of cherished memories and the like. So at this point, no transfer, but if the parties want to work on getting those copies and sharing those, that would be appropriate. The issue related to the home in Mexico, and I should say homes, the purchase of the one and the second, those closing statements of the two Mexico homes should be shared. I'm not going to require an accounting. The request for the address of the new home, the current residence of Mrs. Bosick, that's a tricky one in a lot of ways, because one, there needs to be determination of connection with values and documents with addresses and the like. And then there's the concern for privacy, the need that Ms. Bosick has expressed related to having that peace of mind that he's not going to come down there, which he has on good terms. It sounds like in the past, come down to Mexico and pay maybe an untoward visit. So I don't know how to split that baby, so to speak. I think that the address should be protected. That Ms. McLean should be in a position where she can review those documents. But if there's any times where she shows that those documents to her client, they would have to be whited out, blacked out, so that her client doesn't have knowledge of that address. So I think that's the line I'll divide in between the two. That sharing that information of the closing statements or comparable documents should be shared of the Mexican homes, but not sharing of the address with the client.
And just so I'm alerted, I would ask that there be an accompanied order or notice attached to each document so that I'm alerted and don't inadvertently disclose.
How does that work in practice as far as that order or attachment? Is it just like a cover sheet?
It'd be like a protected border. I'm fine with a cover sheet that just says non-disclosure to Britt Bosick due to temporary order, or something that just alerts me about the address being in an item before we forward that on.
Okay, and that would be something Ms. Winkle's office would attach to, so just giving notice and a heads up.
Yep.
Okay, that sounds reasonable. The next issue relates to assets and maybe preservation of the same. Both parties right now, it looks like Mr. has roughly 64,000 in his account, and Mrs. has roughly 90,000 in her account. I recognize that there's the waters are pretty murky, and there's a lot of discovery that needs to occur. But what I think it would be appropriate, just that a $20,000 transfer from Mrs. Bosick to Ms. McLean's trust account, and those funds would be preserved. It's not the full amount, but it's an amount that can be preserved. And if it needs to go back to her, it'll go back to her. If it needs to be split or go to the father, then it would go that direction. But that'll be part of the order. As far as the spousal request for spousal support, what I see is that both are recipients of Social Security income for the labors that they've entered into for their adult lives. Mrs. Bosick has $2,400 and Mr. has roughly, and these are net figures I'm working with and their estimates, $2,400 for the Mrs. and $2,066 for Mr. And then there's an indication that Mrs. Bosick is receiving, according to the 2023 tax return, some pension monies of roughly under $2,000 a month, $1,900 roughly, and that Mr. has the WANA credit union 401k distribution of roughly $2,000. That should continue to go to him. I recognize that that's limited. There's about 8 months potentially of, and maybe less than that now, of funds that remain. So that puts them in rough parity, although if you add those numbers up, that's roughly 4066 for Mr. and let's see, 4,300 for Mrs. Of monthly net income. What that tells me is that there's likely not a need for any spousal support at this time, with those incomes being on roughly in parity. There's some distinguishment or difference between that. Certainly, when those 8 months of income is dissipated, then that will be potentially in a different situation. And we'll also be in a different situation that there'll be more information known about finances and current state of dollars in each pocket. So I'm going to.
Oh, I'm sorry.
Go ahead.
So is the court then reserving for adjustment once those monies dissipate, or are you going to then order that the pension monies be split pending further order?
I think,
Your Honor,
yes,
I'm a little confused. Those are the pension monies. There's no additional funds. So I'm a little confused because once the one is gone, there's nothing else. So it would just be their Social Security.
Yeah, I think we need to take a fresh look at it once those monies are close to depletion or have been depleted. We need to take a look at that. We could take a fresh look at the spousal maintenance, because that may be a very different story depending on what funds are or are not available.
Okay.
And
all right. So you just reserve at that point.
Yeah, once those funds have been depleted, then it's reserved. It can be addressed newly.
Okay.
I think that addressed the items that the parties raised. I may have missed something, so please share if I did.
I don't, otherwise I assume the court's adopting the balance of my order other than as you've modified. So the household expenses, I'm assuming wife we need to add in there as far as she would be responsible for the Mexico expenses.
The credit card.
Yeah,
I have the
one who owns.
Oh, I missed that. The credit card, and that was the comment.
I didn't hear what
Ms. Winkle said something about the credit card, and then go ahead.
Yeah, so the credit card ending in 4321, I believe is what it is. They were asking for my client to pay it. Mr's the one who spent the money. That's the credit card that we were talking about where he's the authorized user, but he's the one using it. I do have those statements. I can submit them to the court and to Ms. McLean today. It doesn't seem fair given that Mr's giving 4,000 in, my client's getting 2,400 in. Those are, obviously those are very different numbers. And then the credit card, if she were to pay that, she would have nothing to live off of whatsoever.
So I'm a little bit confused because my understanding was that 4321 credit account, that's the one that there's been these regular monthly transfers of varying amounts from the 3875 Bank of America account to the 4321, which the way I interpreted that was just those were purchases made, and then he would transfer money to pay off the credit card on a kind of a monthly basis.
Well, she would.
That's what it sounds like.
She would.
He would,
and and I don't know if those were covering just his or not. So I guess my suggestion at this point would be that she not access the 3879, whatever that account is, and I'll instruct him to stop using the 4321.
That works.
Okay.
As long as my client's not on the hook for his charges, I think that's appropriate.
Okay. So I'm looking at the proposed order that Ms. McLean submitted. So I'm looking at page 2 under provide support. There's going to be some alterations to that in that I'm not ordering support, but it's reserved once the WANA becomes depleted or close to being depleted.
Right.
I'm fine with 7A as far as possession and use of those particular properties. Under 7B, I'm fine with that staying as is, the Hyundai staying with Mrs. and the Juke, and I'll just put just a brief asterisk next to the Nissan Juke, and that requires just basically documentation related to the sale and purchase. Let's see.
Okay.
So let me just add that in here.
I'm going to provide a new one for the court.
Could you repeat that, please?
I'll provide a new order to the court and to counsel.
Okay, that'd be helpful. Okay, thanks.
Oh, okay. I wasn't sure if you said awful or helpful. Was it helpful?
Yes, that was helpful.
Okay.
Helpful was the emphasis on the full and then help.
Okay.
Helpful. And then under 9, I'm fine with that remaining the same for the Kalama home, that Mr. pays and cares for that. And then under the...
And then should we add the Mexico home as her responsibility? Okay.
I think that's clear on its face. Ms. Winkles, any concerns for that?
No, not at all.
Okay. And then the debts here, as far as these are related to some credit card numbers. So the 6441, that Mrs. opened that up, it looks like in October of 22. The 8480 that was opened in February of 24. The 9404 was opened by Mrs. in same February of 2024. So those are fine. The 8597 looks like she opened that in October in 2022. So I'm fine her being responsible for that. The 4321, that's the one that's the recipient that we talked about a little bit before as far as the use. So that may need to be revised. And then the Bank of America Visa, I'm not sure what that one is.
Those last two are the ones that he uses.
Okay.
So I understood that she still had a Bank of America Visa. He does have one that's number 3875, and I'll add that one on there and add language that he's not to use the 4321 and she's not to access the accounts reset.
Is he going to pay that bill if he has charges on there? Is my question, because my client doesn't have enough.
Okay. So I would say get me the information because I don't know what's been transferred at this point. I don't have current statement.
It would seem though
we need to raise those issues at the time of presentation. We can do that, but I'm assuming counsel and I can try and work that out rather than using the court's time.
Yeah, we can take a look at that freshly if there's any concerns.
And we can file those statements too, because we have them So that might help out everybody.
Okay. So 11, 12, 13 are fine. And then I guess 14A would be the $20,000 to trust
Right.
would be revised. And then 14B would be related to the closing statements and the notation as far as protective order, protection of the address.
Yep.
Okay. And the closing statements are just on the the Mexico houses, correct? Because she can't access the ones here. We're having trouble anyway getting the ones from here.
I've already provided the one here. I filed it in.
Not the full amount, not the full thing. So that's what we're trying to get all the closing documents.
Yeah, just fine with the two Mexican.
Okay.
Yep.
All right. So presentation.
We can look at a Friday morning at 8:45. Let me pull up my calendar because I've got some Friday things coming up. 16th may be the earliest time frame. Maybe looking at.
I'm out. Could you do the 23rd?
Yeah, I'm 23rd. I'm available, Ms. Winkles.
I'm available on the 23rd.
Okay. Great.
Okay.
I'll get an order over to Ms. Winkles, and assuming we can agree on the form of the order, then we can strike that.
True.
And that's at 8:45 a.m.
It is.
Great.
Yep.
Okay. Thank you, Your Honor.
Great. Thank
Okay,
you
thank
very
you.
much, both of you. All right. As far as other items on our docket this morning, I think that we have none. So we'll go ahead and disconnect. And thanks everybody for your help.